Hey everybody! It's always good to get back together with everybody that's interested in the Courtney Clenney case. It's also always fun to meet new people that are trying to get into this case, knowing that trial is approaching on April 27th. So it's finally right around the corner. It's been like the can that just seems to just keep getting kicked down the road, but finally it's supposed to be slated for trial. So today was a status hearing. This hearing was scheduled for a month already, but a few days ago, there was a new filing on the docket from Kim and Deborah Clenney, Courtney Clenney's parents. They were seeking a protective order in relation to their iCloud devices. So this is all stemming from that long laptop saga from like 2 years ago at this point. And that issue was added to the docket for the status hearing. So this status hearing was 40 minutes long, and they also set another date to continue the status hearing for April 1st. So another hearing to add to your calendar. To pretext all of that, we're going to take a look at the motion that was filed before we listen to the arguments on it. Let's see. We're going to get, and I'm glad they're going to do this for me. It's been 2 years. They're going to lay out the procedural timeline from this laptop saga with the Courtney Clenney parents and why we're here. They're going to tell us what happened at the appeals court because the parents' attorneys had appealed the decision from the court relating to the seizure of their devices. They wanted their devices returned. The trial court said no, the state, there's reasons that they might want to examine these, and I'm finding that they have the right to maintain and not return these items. And that decision was appealed to the Florida Court of Appeals, who affirmed the trial court's decision. So we're going to get all the background procedural history and what they're arguing for, and then we're going to see them argue this and whatever other issues needed to be handled at this hearing today. So it's going to take us back a little bit, right? We've got to dust off our shoulders here. So Jillian, good to see you. We always got to say hey to Ariel. Good to see you. Martina Nemesis Triple Cat Day. Technically only 2 on my channel. I just came over from Nick Starrow's Friday night panel. So thank you for coming over here. Factual Lie, good to see you. Sheriff Chuck says I can save her. You know, I'm not gonna fight you on that. It's all you. Shanikia Young, good to see you. Got DB in the building. Might be fighting for Courtney here. We've got Tony here. Good to see you, Tony. We've got Maddie, we've got Trakeisha, we've got 5 gifted memberships from Sheriff Chuck to kick off the stream. Thank you so much, Chuck. Bowleg says happy Friday to everybody. And another 5, so we've got 10 coming down. He's really trying to save Courtney. So, Courtney, if your attorneys are watching this stream, please relay the message to Miss Clenney that Sheriff Chuck might be able to save her. And another 5. Thank you so much, Chuck. We're going to put the stop button on you. Don't be so generous. You're so nice. So let's get some love in the building for Sheriff Chuck. Unfortunately, Chuck Norris passed away today. And I know some people might say like, oh, it's a celebrity. You didn't really know somebody. But if you've watched a show like Walker, Texas Ranger, even if you have a family member that watched Walker, Texas Ranger, sometimes those people that are on a screen, even though it's a fictional character, even though you don't know that person personally, they're still a big part of your life. You learn things from movies, you learn things from TV shows, and when someone from that show passes away, that might hit you. And also just the idea that, dang, people get old. People get old. And that's a tough pill to swallow. Like, dang, if that person can die, I'm screwed. Chuck Norris is supposed to live forever. And yes, Shaboogies, he's alive in our hearts. And Char. Chat. There we go. I was like, wait, I don't know what to make of that one. So when I heard the news of Chuck Norris passing away, I thought of Sheriff Chuck. Because love and appreciate Sheriff Chuck, and he is a big Chuck Norris fan. So thank you for your generosity here. Kay Schmidt also in the building gifting 5. Guys, we're up to 20 gifts starting this stream. Thank you, guys. We've got like party balloons in here. And Nick Squad coming over. Good to see the Vikings. With everybody coming in the building, let's get into this motion. If you're on replay crew, I'll timestamp for when we start the hearing if you want to jump to that. So we've got this motion for a protective order to restrict disclosure of sensitive information. And remember, this is really, it's being filed in Courtney Clenney's murder case. It's a relic of the laptop case. And this motion is being filed by Kim and Deborah Clenney, who are really like third parties to this Courtney Clenney case. So comes now the petitioners Kim and Deborah Clenney, by and through their undersigned counselors. And I never really see that written that way. So kind of interesting to see the word switch. And respectfully removes this honorable court for an entry of its order restricting the sensitive and private iCloud data seized pursuant to the search warrant issued in the above-styled case. In support of this motion, undersigned states as follows. So facts relevant to the motion, sub judice. So Kim and Deborah Clenney are the parents of Mrs. Courtney Clenney, who is the defendant in Miami-Dade case ending in 14137. That's this case. The petitioners are both listed by the state of Florida as witnesses in the same case. In this case, the state has charged defendant Courtney Clenney in the death of her boyfriend Christian Obumseli. The homicide occurred on April 3rd, 2022. So we're like a week and change away from 4 years. 4 years. At the apartment of the defendant Courtney Clenney, Juan Paracio, which Nick Starro just shared on his panel stream. He visited the Juan Paracio building with Steve Gosney. So that was cool to, anyone that was over there got a teaser for this stream, which she shared with the decedent. On August 10th, 2022, the defendant in this case was arrested while in a treatment facility in Hawaii. So if you're new to this case, just know that there was a big social outcry. You know, why aren't you arresting Courtney Clenney? She killed somebody. She's at this bar in a hotel drinking. Someone posted a video of her out at a bar drinking. And there was this gap in time. And I do think the public call to pressure, and maybe the investigation was ongoing. Some mix of those variables, somehow months later, we're finally getting an arrest warrant. So the defendant has been charged with second-degree homicide. And there's also, it's going to be aggravated because there was the use of the deadly weapon, the knife. During the state's investigation into the homicide, they attempted to access the cell phone seized from the defendant. When initial attempts were unsuccessful and counsel declined to provide the access code, the state opted to make an end run around due process and proper investigative procedures by securing a search warrant for the parents' iCloud accounts. An iCloud account is a cloud-based storage and syncing system linked to Apple devices and contains a trove of a person's personal information, including, but not limited to, financial information, medical records, photographs, personal notes, and private communications. The search warrant for the iCloud accounts of Kim and Deborah Clenney listed a time period of November 2020 to, quote, present. The warrant was first executed on February 2nd, 2023, making its scope approximately 2.5 years. The homicide in this case occurred on April 3rd, 2022. During the time of the homicide, both Kim and Deborah Clenney were in Austin, Texas, approximately 1,352 miles from Miami, Florida. The state has not alleged that either Kim or Deborah Clenney had any involvement in the death of Christian Obumseli. Yet, by and through its application, the state sought to take possession of Kim and Deborah Clenney's entire personal digital information for a 2.5-year period. The warrant being used to pursue this personal data provides for a broad time period and in no way limits the search to items related to the defendant and the decedent's relationship. We've got a footnote here. It says additional facts and issues with the request and the warrant are set forth in more detail in the undersigned counselor's motion for return of property and to quash search warrant. So these are in reference to prior filed motions. And you see this big footer here, Ratson and Faccidomo. I don't know much about Ratson. And this is not, what I'm about to say in praise of Faccidomo is not meant to be leaving Ratson out. But Faccidomo makes a lot of arguments in relation to individual privacy rights. So if we remove ourselves from thinking about Courtney Clenney, like whatever you think about Courtney Clenney, if we remove the context of an individual case and we look at the idea, if somebody is not charged with a crime, but they may have communicated with somebody, how do we feel generally about the idea that police officers could issue a broad warrant to obtain their iCloud information, to obtain their devices, and then hold those same devices for years? For years. Is that an invasion? Is that too invasive? So this type of privacy issue, I think it's interesting to see argued. And I think Faccidomo, if you go to his website, he has a legal blog. You can see some of it, but his name has popped up in quite a few proceedings in Florida that relate to these privacy issues. And he also used to be vice president of Florida's Association of Criminal Defense Lawyers. So he advocates for other criminal defense attorneys as well. So just an interesting top level issue that's embedded in the context of this case here. So back to this procedural history here, we have on September 5th, 2024, the Kim and Deborah Clenney moved to intervene in the instant matter. So that's defense exhibit number 235. Contemporaneous with the request to intervene, the Clenneys moved to quash the subject search warrant and return to them the hard drives containing their private and personal material. Following a hearing on the motion, the court denied the motion to intervene. Subsequently, undersigned counsel filed a motion for reconsideration, citing the court to Florida State Constitution, Article 1, Section 23. On October 28, 2024, the court again denied the Clenney motion. On November 12, 2024, the Clenneys filed their notice of appeal of the trial court's order and proceeded with the appellate process. So they filed that notice of appeal of that decision all the way back in November of 2024, and then a month ago, February 25th of this year, the Third District Court of Appeals, per curiam, affirmed Judge Cruz's denial of the petitioner's motion to intervene. So that's how long that process was taking. The petitioners now move, pursuant to Florida Rule of Criminal Procedure 3.2201, Section 1, and M1, to limit the disclosure of private and confidential information obtained by the state through the subject search warrant. So now it's not, the fight to get their devices back has been, exhausted for practical purposes. So now what we want to do is make sure that the information that's in the state's hands, that it's under seal, that it can't be disseminated. It's not something, can I go request this? I have all of Courtney Clenney's personal notes from her iCloud download. We want to prevent that from happening with what might be in the parents' devices. So Kat can't just go and request all that stuff. So that's the request here. That's the available remedy that they're seeking now that they just can't get all that other stuff quashed and the devices returned. I see Murph's in the building. It's been a while. Good to see you, Murph. Good to see you. And good to see you too, half Irish. We've got the law. And again, this is Florida State, but I think this issue transcends the concerns of any one state. So on February 25th, 2026, the Third District Court of Appeals disappointingly affirmed this court's order denying the Clenneys' right to intervene pursuant to Florida Rules of Civil Procedure 1.230. Notwithstanding that order, it would be ludicrous to argue that Kim and Deborah Clenney do not have a privacy interest in 2.5 years of data contained in their personal iCloud accounts. Aside from the sheer volume of data, the type of material contained within the iCloud and now housed on the state's hard drives is deeply personal and intimate. iCloud is a digital safe. Contained on the hard drives now in the court's possession are all manner of private data such as medical records, spousal communications, attorney-client confidential communications, personal photographs, and financial information. The state's argument that a, quote, filter team will be used to review the data and will prevent disclosure to the state's trial team confidential information only serves to protect Courtney Clenney from having privileged information used against her in trial. But it does vindicate Kim and Deborah Clenney's privacy rights under Article 1, Section 23. So, Courtney Clenney has a right for things to be filtered. So if there's somehow any discussion of her case, again, conversations between the defense team that may involve Courtney and her family that's expected to be confidential, or conversations that might be with the defense team for Courtney Clenney in furtherance of her defense strategy are supposed to be filtered. But that type of protection doesn't apply to Kim and Deborah here because they're not being charged with anything. So the issue being presented to this court on behalf of Kim and Deborah Clenney, the owners of the data in question, is not one of trial admissibility at Courtney Clenney's trial or legal confidentiality, but rather of privacy. The petitioner's privacy right is enshrined in the state constitution, and allowing even a single government personnel access to that violates that constitutional right. The Third District Court of Appeals affirmed this court's denial of the motion to intervene, so the petitioners now move, I think that's a typo, now move pursuant to Florida Rule of Criminal Procedure 3.221 and M1 to limit the disclosure of the petitioner's private and highly sensitive personal information. So yeah, I know this might be boring, but I just love when we have legal writing that I feel like I'm learning something. Like, here's an attorney team that's distinguishing. Some of this would be not admissible anyway, but it doesn't cover what we're asking on behalf of Kim and Deborah. Additionally, we're not attacking this from a legal confidentiality issue. This is a matter of privacy rights, and here are the relevant statutes. And I just think it's interesting to see the way attorney brains think. So the information sought to be reviewed by the state is the petitioner's private data. The petitioners are not charged with a crime. Nevertheless, they have a very real interest in the proceedings, as it is their personal and private data that is being reviewed and exposed by the government. While the Constitution of the United States does not expressly create a privacy right, the Fourth Amendment does protect private citizens from unlawful searches and seizures and has been interpreted to create a privacy interest. More germane to this motion, the Constitution of the State of Florida, Article 1, Section 23, provides express and robust privacy protections, stating, so right of privacy. So they're enumerating that in the state constitution, that there's some kind of right to privacy. Every natural person has the right to be let alone and free from governmental intrusion into the person's private life, except as otherwise provided herein. This section shall not be construed to limit the public's right of access to public records and meetings as provided by law. So as noted in Winfield v. Division of Pari Mutual Wagering, so we're going back to a Florida case from 1985. The citizens of Florida opted for more protection from governmental intrusion, shout out to them, when they approved Article 1, Section 23 of this. So what they're saying here is the holding in this case, they're making it clear that the intent of whatever was underlying what's written in Article 1, Section 23 was more protection. So when we look at this, we should not assume that it's supposed to be less. So I'm glad you don't think this is boring. I'm glad you do not think this is boring. I think it's cool, especially since we're getting into, hey, Constitution, the United States Constitution versus what Florida's doing, I think is really interesting. So this amendment is an independent, freestanding constitutional provision which declares the fundamental right to privacy. Article 1, Section 23 was intentionally phrased in strong terms. The drafters of the amendment rejected the use of the words, quote, unreasonable or, quote, unwarranted before the phrase governmental intrusion. Oh, so think about that. Imagine you're reading a sentence and it's like, natural persons should not be subject to unreasonable governmental intrusion. Verse reading, natural persons should not be subject to governmental intrusion. And then blah, 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 maybe followed by that invades their privacy right. That's a very big difference, because when you have these precursor words, these modifying words, you add in room for interpretation. You add in room for greater subjectivity. So the drafters of this didn't want that additional expansion of the subjectivity. So let's see where this goes. The drafters of the amendment rejected the use of the words unreasonable or unwanted before the phrase governmental intrusion in order to make the privacy right as strong as possible. Since the people of this state exercised their prerogative and enacted an amendment to the Florida Constitution, which expressly and succinctly provides for a right of privacy not found in the United States Constitution, it can only be concluded that the right is much broader in scope than that of the federal Constitution. The state has previously argued, so now they're talking about the prosecution in the Clenney case. So the state has previously argued that the petitioners lack recourse with this court because they are not defendants in the pending case and therefore lack the standing to seek the remedy of suppression. Do you like that sentiment? Again, remove the Courtney Clenney context. Or actually include it, because a judge found that they invaded. They read, even though Courtney Clenney is entitled to certain protections, certain communications that should have been filtered through a taint team, that the state attorney, Khalil Quinnen, failed to employ that filter and viewed communications and violated. He wasn't supposed to look at certain communications, and he did. So maybe leave the context in, because that's the danger. So even though the state here is leaning, according to the argument here from Kim and Deborah Clenney's parents, that, oh, the state's saying, well, only the defendant has this standing. Well, you stepped over the line for the defendant. So I still have a problem. But again, big picture, I think this is a great thing to consider. Do you want the state to be able to argue that if somebody's not a defendant in a pending criminal proceeding, that they don't have the standing, they don't have a pathway to ask a court that, hey, since you obtained my information to use as part of an investigation and prosecution in this case, I have no privacy rights because I'm not a defendant that you're charging criminally. You can just look at anything and hold it as long as you want. This is a big deal. And of course, that's the state's argument, right? The petitioners are not seeking suppression. So Kim and Deborah aren't seeking suppression. Rather, they assert the warrant secured for their personal data is on its face overly broad and a violation of their constitutional right to privacy as guaranteed by Florida's Constitution. Consistent with this analysis, petitioners aver that the amendment provides, quote, an explicit textual foundation for those privacy interests inherent in the concept of liberty, which may not otherwise be protected by specific constitutional provisions. And that's from Rasmussen versus South Florida Blood Service from 1987. The state's argument that the Fourth Amendment provides no protection, so the state's relying on the U.S. Constitution Fourth Amendment and saying that doesn't provide protection to the petitioners as they lack standing, while legally accurate, reveals a troubling position. If the petitioners have no remedy in the court to challenge strangers reviewing their most secret information, then where do they seek redress? Moreover, the petitioners have now sought and lost the appeal of their motion to intervene, further highlighting that they are simply at the whim of the state and what it, quote, believes may be relevant to their prosecution of the petitioner's daughter. This leaves the petitioners with one final avenue of relief, albeit imperfect, to seek the trial court's intervention through the rules of criminal procedure governing discovery. The state has argued that they seek this data because the defendant, quote, may have communicated with her mother and or father about the nature of her relationship with the decedent. If uncharged citizens cannot seek judicial intervention from a trial court, then the state can traps through the private data of any individual, even peripherally related to the defendant or case. Ipso facto, then, every citizen in Florida who knows or is related to a defendant and, quote, may have spoken to them about something relevant is subject to having years of their personal data traipsed through by the government. As argued in their motion for return of property and or to quash search warrants. So this is the article, these are the motions that were denied and then appealed. This court retains jurisdiction over the warrant issued for the iClouds and hard drives. While the magistrate's determined that probable cause exists for issuance of a search warrant is entitled to great deference, it remains the duty of a reviewing court to ensure that the magistrate had a, this is quote, substantial basis for ... concluding that probable cause existed. In retaining that authority and through the previous motion, and having again been vested with jurisdiction via the mandate issued from the 3rd District Court of Appeals. So since the Court of Appeals has made a decision and is no longer hearing the issue, jurisdiction is now back down with the lower court. The petitioners are praying this court will exercise its authority via the rules of procedure to protect the petitioner's sacred privacy right under Article 1, Section 23 of the Florida State Constitution. So another argument here. The warrant must be narrowly tailored. Florida Statute 933.04 requires that an affidavit in support of a search warrant be pled with particularity. Unfortunately, the 3rd District Court of Appeals per curiam affirmation of the trial court's order leaves this court without guidance on the substantive issue of the invasion of the petitioner's privacy. While the appellate court upheld the trial court's denial of the petitioner's motion to intervene, the issue of the state's right to the private data on the hard drives remains unclear. The probable cause affidavit from the 3rd District Court of Appeals presumably affirms, right from the 3rd, it's just kind of blank here. The probable cause affidavit from the 3rd presumably affirms the denial of the motion to intervene, but does not provide insight as to its appellate court's disposition on the more substantive issue of the validity of the warrant. The state has maintained it has a prevailing interest in investigating the pending homicide, and that their need to investigate renders any privacy interest ostensibly null. There's a lot of typos in this that are impacting my reading. Some of them I can piece, but I think this is supposed to be Annie, renders Annie. While the petitioners concede that the state interest in prosecuting the homicide has merit, it also has limits. At the motion to intervene hearing, and this is why I remember this heading, is the warrant must be narrowly tailored. So they're saying, we get that the state has an interest in being able to investigate something, but it can't just be infinite. It can't just be boundless. It can't just be as broad as they want it to be because they may find something willy-nilly whenever they want to. So at the motion to intervene hearing held on September 11th, 2026, we're in the future. The court inquired of the state what the basis was. I think this is 2024 procedurally. The court inquired of the state what the basis for the warrant was. The state referred to the court to the probable cause section of the affidavit. The petitioners again invite the court to review that section in detail. It does not identify anything specific that the state believes would be evidence related to the homicide. Rather, it references what are essentially hunches and speculation. And this proceeding was under Laura Sharon Cruz. So the presiding judge for the trial and any motions until trial is now Andrea Ricker-Wolfson, the one who used to be an ASA. So she used to be a state prosecutor. The one aspect of the iCloud account that the state referenced with specificity was the fact that the defendant, Courtney Clenney, was potentially on the phone with her mother at the time of, or close in time to the homicide. So the specific mention we get in this probable cause affidavit is during. So this would have been on April 3rd, 2022. During this incident, when the crime is actually occurring. Courtney may have been on the phone with her mom. That's specific, but that's also a very narrow point in time. So they continue that assuming in arguendo, the state has a good faith belief that the defendant was communicating with her mother at the time of the death, it begs the question, why did they need such a broad scope of both the defendant's mother's data and the defendant's father's data? The same can be argued with regard to the photographs. And quick sidebar here, but the journal notes I have from Courtney Clenney, they go back to like 2011 or something like that. Like, was that really necessary? So I don't know. It was interesting to me, don't get me wrong, like interesting to see someone who would become an OnlyFans model and documenting her life through the years. I almost said through the months, but through the years. But really, like, the relevant points in time and the relationship with Christian Obumseli, I mean, that window was like a year and a half before this 2022 incident. And yet there's a decade and change of her notes. And like the notes app, when I'm saying it's her notes app, she was using it like a journal. She had a grocery list in there. She would document what happened that day. She would put reminders in for her appointments and things like that. Like, she used it like a journal. There was a lot in there. The extraction was like 300 something pages. So that's a lot. I think that's pretty broad. And she's the actual defendant. So the state's the subject of the investigation. So the state's warrant application seems to imply that defense counsel or the defendant's mother intentionally deleted photographs before voluntarily providing them to the state. The photographs in question were part of a sequence documenting the serious injuries sustained by the defendant at the hands of the decedent. They were voluntarily turned over to the state's attorney's office, and yet the prosecution has intimated that because some of the photos in the chain of those provided are missing. So like think of the file name as like photo 1, 2, 3, 4, and then it jumps to like 7. I'm assuming that's where they're thinking this is happening. The prosecution has intimated that because some of the photos in the claim, the chain of those provided are missing, there must be something of evidentiary value to the state on those missing images. That is both inaccurate and without basis. Moreover, even if the court found a compelling interest in the state seeking those photographs, and or the communications close in time to the homicide, that would not explain why they are justified in searching 2 to 3 years, searching through to 3 years of unrestricted data. And what do you think about that argument? What do you think about that argument? And again, this issue with the return, they voluntarily brought pictures to the state. This wasn't like responding to a subpoena, we want all pictures taken from this date range, and the files are in. They volunteered a set of pictures that they felt were relevant. So, let's see. Allowing the state to proceed under such a broad and unrestricted application for the petitioner's data in direct violation of their constitutionally protected right to privacy. And this is kind of like a weird, disjointed sentence, but there's a paragraph here in quotes. Since the privacy section as adopted contains no textual standard of review, it is important for us to identify an explicit standard to be applied in order to give proper force and effect to the amendment. So they're talking about this privacy rights amendment to the state constitution. The right, Article 1, Section 23, right? Yeah. The right of privacy is a fundamental right which we believe demands the compelling state interest standard. This test shifts the burden of proof to the state to justify an intrusion on privacy. The burden can be met by demonstrating that the challenge regulation serves a compelling state interest and accomplishes its goal through the use of the least intrusive means. The state's warrant seeks to search through the defendant's parents' iCloud account for 2 years prior to the homicide to 1.5 years after the homicide. It lacks any specificity and has no restriction on what documents, photos, or communications they can comb through. During the September 11th, 2024 hearing on petition, they got the year right, on petitioner's motion to intervene, the court asked Assistant State Attorney Quinnen, who he's the one that stepped down now, quote, "What power do I have as a judge now to protect some of the more private data that is not relevant to this case?" And then they cite the transcript. While the state did not directly respond to that inquiry, the question remains an important one and is better posed to the petitioners. If the court maintains that the prosecutor's hunch is a compelling interest surpassing the petitioner's fundamental and constitutional right to privacy, the petitioners then request the far less onerous remedy of ordering that the warrant be sufficiently narrowed to include specific items of data contained within a time period relevant to the homicide. Alternatively, the petitioner would ask the court to apply Florida Rule of Criminal Procedure 3.220M1 and review the hard drives in camera, so like the court can view it on their own with the parties present, and determine if the state has a legitimate interest the data contained therein as it pertains to their homicide prosecution of Courtney Clenney. The court is aware of the severity and breadth of the warrant at issue and the extremely private nature of the data being held, and yet the state has failed time and again to narrow or identify what specifically they believe they will find relevant to the homicide charge against the defendant. The state instead relies on innuendo and vagaries to distract the court from the comically broad, they called it comically broad, the comically broad nature of their unconstitutional intrusion. Tell them. Tell them. Then we have Florida Rule of Criminal Procedure. Well, let me see what you guys are saying. Yeah, so Denise said, "I'm trying to figure out why she would take pics of injuries she inflicted on him, or am I lost?" I think what they might be referring to is there was a set of pictures that Courtney's mom had provided, and they were floating around. I think I have some of them, and I've shown some of them before. But it's like bruises that Courtney Clenney had, and it was a few days before. I think it was, she already had them before April 3rd was the issue. Which would mean that they couldn't have been caused during some type of struggle in the home on April 3rd. Because Courtney's claim, at least in her interview with detectives on April 3rd, was that, hey, we were fighting and he ran over to me and he took me on the ground and he had his hands around my neck. I thought I couldn't breathe. And then when I finally got up, I ran away from him. And she says that she's this 10 feet away. She's telling him to stay away from her. But then he looks like he's going to come near her and she takes a knife and then throws it at him. So this part, obviously you wouldn't think that somebody would have bruises from just throwing a knife at somebody. But it's the part leading up to that from her story where she says, were on the ground in this tussle and I felt like I couldn't breathe because he was choking me, you'd expect some bruises. So these pictures that were provided, they may have been bruises, but the pictures were taken before April 3rd. So they couldn't have been in relation to what led up to the instant crime. So, and yeah, so not unrelevant, because there could still be an argument, well, she had bruises days leading up to that, and there was animosity, there were these conflicts. She was asking for a restraining order. Like a few minutes into April 2nd, it was like a midnight incident on April 1st into the 2nd. And then that's where we get that video of her in the lobby saying, I haven't always been the victim, but this time I am. And I want a restraining order against Christian Novomselli. So the bruises could be relevant in some way, but they don't. I think the mom thought, oh my God, I have these bruise pictures. And the state thought, well, this couldn't be from the same day, but they might still be relevant for other reasons. But in any case, there's pictures in between that weren't provided. And the state was using that as a reason to say, we want this very broad search warrant application. So, and again, I think there's a broad question that I'm looking at removed from the Clenney case. But then when you put the Clenney case back in it, I go back to, well, we couldn't trust Khalil Quinnen when he was the lead prosecutor on this case with the information he had in front of him to properly filter it in relation to Courtney Clenney's interests. So do we really want to let someone like him have the opportunity to go to a magistrate judge who'll sign off on an a comically broad warrant, where he can go and get these devices and he's not going to follow his rules that he should be following? And just because he has a hunch for someone that's not even the subject of the investigation, isn't going to be, never is criminally charged with anything. They might be related in some way, but do we want to let that invasion of privacy, is that enough because the state has an interest in prosecuting this one defendant to have that much of a broad scope based on a hunch that they might have relevant information? I think it's a really important question. Really important question. And Florida specifically, based on what I'm reading in this, and this Article 1, Section 23, it seems like Florida has already said, no, we don't want to allow comically broad intrusions. We have explicitly and expressly provided, some measure of protected privacy rights for our citizens. So, yeah, and one of the things for Always Serve for Life says it would show a pattern of abuse from Courtney towards Christian. One thing about bruises to me is, depending on where that bruise is, the person with the bruise isn't necessarily the one, if the bruise is even from a physical interaction with another individual. Someone having a bruise doesn't mean that they were acting defensively and they were the one being aggressed. Somebody could have bruises or scratches because somebody else was trying to defend themselves against them. So bruises are always an interesting thing to hear. Just because someone has bruises doesn't necessarily mean that it's from an injury someone inflicted upon them. Trikisha, have a great Friday night. Yeah, Sheriff Chuck says, also remember, Courtney is currently innocent. So she's innocent until proven guilty. Right? And that's the legal standard. That's the presumption that everybody should have. And then her parents are also not charged with anything in reference to this. So I'm with you. I don't think that this is right. And I'm glad we're reading this beforehand, because I kind of wonder if this, spoiler alert, this motion was granted. I saw it on the docket, but I wonder if it's going to be a shorter argument in court, because the judge already is looking at the statute and is like, yeah, I'm going to grant this. So if we just went right to the status hearing, we might not hear this fleshed out quite as much as it's fleshed out right here. And again, I think the procedural history, refreshing on what's happened since 2024 and then learning what the District Court of Appeals heard, because I didn't know that decision came down. I just knew that they were appealing it 2 years ago. So I think it's a big deal. And yeah, Trev says knuckle bruises are sus. I mean, yeah. Or even swelling on the knuckles. Scratches. I'm thinking of also Chris Melton as a recent example. Injuries on hands that kind of look like singed hairs missing. Because in the Edric Foss case, with what happened to the victim Tara Baker, there was a fire involved. So, scratches might just be like, oh, they could be from work, but why does it also look like your hair singed off? So, yeah, and for always also said for the journal will show the pattern of abuse. And you guys know me, I'm not going to I will go into the case tallying step for step. Do I think the state is arguing something that proves their case? But just as a personal opinion, Courtney Clenney saying in her journal notes that she hits Christian to relieve tension in what seems to be a note to herself to tell herself to stop doing that. Yeah. Signals that the reason behind the hitting isn't defensive. So, and that stuck with me from her journal notes. So, let's go, guys. We've got Section 4. Florida Rule of Criminal Procedure 3.221 and M1 govern the disclosure of sensitive witness material. So while the petitioners in this matter originally sought the more robust remedy of intervention through Florida Rule of Civil Procedure 1.230, the appellate court has since upheld this court's denial of the right to intervene. The petitioners are now relegated to relying on Florida Rule of Criminal Procedure 3.221.1 to protect their rights. Florida Rule of Criminal Procedure 3.221.1 governs protective order pertaining to witness and states in pertinent part. All right, motion to restrict disclosure of matters. On a showing of good cause, the court shall, at any time, order that specified disclosures be restricted, deferred, or exempted from discovery, that certain matters be not inquired into, that the scope of the deposition be limited to certain matters, that a deposition be sealed, and after being sealed, be opened only by order of the court, or make such other order as is appropriate to protect a witness from harassment, unnecessary inconvenience, or invasion of privacy. I think this will do a lot of heavy lifting in Florida if we consider privacy rights as being expressly enumerated in the state constitution. Right? This is very protective based on what it seems like we've got in our state constitution down here in Florida. This protect the witness from harassment or an unnecessary inconvenience, maybe that's a little bit more vague. And then including prohibiting the taking of a deposition. Interesting. All material and information to which a party is entitled, however, must be disclosed in time to permit the party to make beneficial use of it. Both Kim and Deborah Clenney are listed witnesses by the state of Florida in the case against their daughter. Additionally, even if the Clenneys were not listed as witnesses, Florida Rules of Criminal Procedure 3.220M1 allows for anyone to petition the court to restrict disclosure of sensitive material. Stating Section M, in camera and ex parte proceedings. Section 1, any person, and that's emphasized, may move for an order denying or regulating disclosure of sensitive matters. The court may consider the matters contained in the motion in camera. More importantly, the court should note that the breach of privacy is a result of an overly broad warrant. Based on that warrant, the state brought frivolous charges against... they went through all their procedural stuff and they said, well, now we're just going to unleash why we're pissed. So I said, more importantly, the court should note that the breach of privacy is a result of an overly broad warrant. Based on that warrant, the state brought frivolous charges against Kim and Deborah Clenney based on the unlawful search of their iCloud data, breaching attorney-client privilege. Incredibly, the state now maintains that they have no standing to protect their own data from outside intrusion. The breadth of the breach of the Clenneys' privacy by the state of Florida cannot be overstated. In our digital world, a person's iCloud account is the equivalent of a digital vault used to store their most private information. Here, the state is attempting to misappropriate a standing argument to try to keep the Clenneys from asserting their constitutional right to privacy. The wide capacity and sanctity of what is contained in technological devices was addressed by Chief Justice Roberts in his opinion in Riley v. California. So this is a SCOTUS case from 2014. And here is what Roberts wrote. Notably, 2014 I'm going to emphasize because he's opining here on what modern cell phones their capacity in 2014, a decade and 2 years ago. Notably, modern cell phones have an immense storage capacity. Before cell phones, and I don't really remember, guys, this is me, I'm straying. I don't really remember when it was, but I feel like it was within the last like 4 or 5 years where every single application that I have, it started like maybe around 2016 with Snapchat, Instagram, where, you know, you could like archive stuff, and Snapchat will store your uploads in a cloud even though you didn't need to keep them on your device anymore. And now it's like almost incessant, and companies want to make you pay to access your Snapchat's done this now. You have to pay for premium to access cloud storage from over a certain time period ago. And I log into my phone, hey, sign up for OneDrive, sign up for your OneCloud storage. So I feel like cell phones had this increasing hardware capacity to store files. But now there's also this increase. Every single app you use seems to have cloud data, or it's a benefit of using the service. So what Roberts is talking about in 2014, I think it's like magnitudes more now. So they say, notably, modern cell phones have an immense storage capacity. Before cell phones, a search of a person was limited by physical realities and generally constituted only a narrow intrusion on privacy. But cell phones can store millions of pages of text, thousands of pictures, or hundreds of videos. This has several interrelated privacy consequences. First, a cell phone collects in one place many distinct types of information that reveal much more in combination than any isolated record. Second, the phone's capacity allows even just one type of information to convey far more than previously possible. Third, data on the phone can date back for years. In addition, an element of pervasiveness characterizes cell phones but not physical records. Modern cell phones are not just another technological convenience. With all they contain and all they may reveal, they hold for many Americans the privacies of life. The fact that technology now allows an individual to carry such information in his hand does not make the information any less worthy of the protection for which the founders fought. So, you know, I think this is cooking. I don't know this opinion. I only know it was quoted here. I'm like, heck yeah, our founders did fight for that. So fortunately, and notwithstanding, and that's a reminder. Just because I think there should be, we should change how we view privacy rights, because what could be private information and how it's stored has changed drastically and probably will continue to change drastically quickly. That doesn't mean I think people should not have their own discernment when they decide what to do with their information, where they store their information. I think you should always be aware that your information, whatever you do, might have a footprint somewhere. So don't rely on the remedies to come through to you in legislation or case law. Have some control over your own decisions and what you decide to put out there and store somewhere. So let's see, we've got, fortunately and notwithstanding, I'm seeing this here, Science and Sass, love the name, says it's absurd to claim a person doesn't have standing in a matter regarding their own property or information. And I think, if I remember correctly, I think one of the arguments that the state made at the 2024 hearing, and I really don't know if that's what they're continuing to argue in response to some of these arguments, but the idea that for the iCloud, it's not actually the parent's property. And I don't know how that would apply to the hard drive from the cell phone device itself, or any like hard drive material. But as far as the iCloud, I do remember an argument that, well, it's not their property. So they don't have, the right through the claim that that's their property. Right? And so Faccidomo, one of the reasons I was shouting him out at the beginning, I should have laid out more specifically, is he's making arguments that just because service providers own where something's stored, we shouldn't just, it's not a good idea for us to just relinquish privacy rights because a company is servicing the host of where that data is stored. So he's been an advocate to not view, property ownership not belonging to the individual who's making, saving, noting the content, and making it so it's stored on this type of cloud server. Whereas right now, the state's arguing, well, it's technically the property of Apple. So, yeah, so that's like another layer, right? Another argument there that I think was fleshed out more in 2024. But yeah, so the state did have an argument for that. They're going to say it's not their property. It might be their information, but they argue it's not their property. So, yeah, and right here. So Max says that might be true. Service providers do everything they can to own everything in the conditions you never read. And they might only be doing that for the sake of they want to be able to give money to marketers, know how to put the right advertisements in front of you so people will pay them more to run their ads, to train their own AI systems. They want to use your information. Like the service provider themselves might not be intent on, well, we want rights over this so we can respond to subpoenas, like to help prosecutors. But it does create a pathway where prosecutors are able to subpoena the owner of the cloud server. So, yeah, it's getting extra complicated, and, you know, I think the legislation, the case law takes the scenic route. But the technology is just like, you know, what's that, I know it, I promise I know it. What's that, the Autobahn? Is that where you can, like, drive fast? Technology's on that. And the case law and the legislation are on, like, driving through a school district, and they have, like, the 25-mile-per-hour limit. So the argument continues here. They say it would be disingenuous and nonsensical for the state to object to this motion by suggesting that the petitioners do not have a very real and vested interest in maintaining the sanctity of their personal data and objecting to the government's brazen breach of their constitutional right to privacy. Oh, wait, I missed a sentence here. Sorry. Run it back. Fortunately, and notwithstanding the per curiam affirmation from the 3rd District Court of Appeal, the petitioners find themselves with another avenue of relief under the rules of criminal procedure. So it'd be both disingenuous and nonsensical for the state to object to this motion by suggesting that the petitioners do not have a very real and vested interest in maintaining the sanctity of their personal data and objecting to the government's brazen breach of their constitutional right to privacy. So we've got, let's see, Florida Rule of Criminal Procedure 3.220M1 provides a proper procedure to respect the state's claimed interest while still protecting the petitioner's constitutional right to privacy. The state's warrant and subsequent clamoring for the return of the hard drives is the textbook definition of a fishing expedition. The state has been unable to articulate precisely what they're looking for, or even why they believe that the appearance of a defendant's personal iCloud has information related to a homicide. Nevertheless, presuming the court finds correctly, I love it. This is like a little bit of magic spice here, right? Nevertheless, presuming the court finds correctly, like in other words, presuming the court agrees with us, which would be correct, that the hard drives contain sensitive data and restricts its disclosure, the state still has the remedy of an in-camera inspection by the court to determine what, if anything, is related to their prosecution of Courtney Clenney. So this argument right here is they have a pathway where they could overcome any prejudice. They'd still be able to look and see what they want, but they just wouldn't have this limited forever access to it. Well, we don't really know if their privacy rights are going to just be on a handshake protected. So the petitioners respectfully submit that their personal data has no correlation to the homicide charge against their daughter. However, provided the state can actually make a prima facie showing that there is something worthy of investigation on the hard drive, the petitioners would request that the court do its own in-camera review prior to granting any access to a member of the Miami-Dade State Attorney's Office. Wherefore, Kim and Deborah Clenney, the proper owners of the digital property unlawfully seized by the state of Florida, respectfully moves this court for an entry of a protective order prohibiting the distribution and or review of their personal iCloud data. And then we've got, and trials coming up, like, trials coming up. So does the state, if the state hasn't gone through this, if the state hasn't already gone through this, but they're still pursuing the case against Clenney, surely they have a case without it, right? you know? So, and then they go. They send that in, and it's Jude Faccidomo and I think Mickey Retzon. Maybe it's Mikey. So shout out to both of them. I'm more familiar with Jude, but I think this is excellent advocacy, and I think the advocacy extends beyond the client. I think it's an important issue. So, also Exile says, came here from Afroman and stayed. Love to hear it. Good to have you. I think it's always fun to read motions. It might not be the most like exciting. There's colorful things on screen. It's just words, but I think it's a lot of fun. So thanks for hanging out. And also saying that Chuck, you're the best sheriff. He is. See? And yeah. So Denise also said, but if I store my belongings in a physical storage building I rent, it doesn't mean my belongings belong to the owner of the storage building. So true at first, right? But if you abandon it, right, if there's whatever the clause says, because there's always some agreement, like at some point it could be considered abandoned. Like if you're not making payments, if you're not responding to communications, whatever the terms and conditions say. Once it's abandoned, now it can become that. And, you know, although I do wonder like what a subpoena for a storage unit, what the burdens are in different states. Because I'm sure law enforcement can get search warrants on storage units. But I wonder like if there's like different procedures that they have to go through with the owner of the facility. Like, first of all, verifying that it was properly rented by the person that they're, you know, the subject of their investigation. But at the end of the case, the search warrant is for us to go into your storage facility with the understanding that what's inside of it is still technically the property of the individual we're investigating. So, good times. And yeah, EJF says, my landlord can't just walk into my apartment whenever he wants to, because even though he owns the building, it's my home still. Yep. Oh, and that's such an important right, I think. There's nothing that I think creates more tension in someone's lives than having to deal with a pain in the butt landlord, an invasive landlord, because it pervades every day of your life. You know, so there's nothing better in life than liking where you live. You know, it can take a lot of stress off your shoulders when you move to some place that isn't filled with stress. So let's see, we've got, yes, background on this case, the accusation, it's a second-degree murder charge. Courtney Clenney is charged with the use of a knife, of killing her boyfriend, Christian Obumseli, in April of 2022. So as the case gets closer, I'm going to do a whole case primer. There's a playlist in this channel. Like if you really want to go down the rabbit hole, there's like 60 videos in it of every hearing that's available. The only thing I didn't really do straight through so far was the first bond hearing and the interrogation video. Because I initially wasn't going to look at this case at first, but we'll watch those. We've looked at parts throughout the streams, but we'll watch those as we do our primer as well. So Judge Simpson has a crazy landlord case. Yeah, he's the one to handle them. All right, guys, so we're going to get to the hearing. And remember, this status hearing was scheduled before this motion came on the docket. So although I think this is like a timely, you know, this issue, maybe it took priority. We'll see. So let's get into this. This is on a weird player. How do I turn these? Let's make sure the captions are good. We'll get, oh, we don't want semi-transparent. We'll leave it in the window. Window. I don't know what window means. All right, so let's see what these captions look like. The volume is, we'll start at half in case it's loud.
Good morning, Your Honor. On page 11, it's under Courtney Clenney, but I'm here on behalf of him and Deborah Clenney, who are present on the platform. Ms. Sabrina Puglisi, who does represent Courtney.
All right, so this guy in the gray here is Jude Faccidomo.
Yes, Judge Sean Abbey on behalf of the state.
Good morning, everyone.
So, Your Honor, we're here on the petitioner Kim and Deborah Clenney's motion for a protective order. Just point of housekeeping for the procedural matters. We had previously moved to intervene on the same issue. Judge Cruz had ruled against us. We took an appeal of that order. Judge Cruz's order was affirmed, PCA. The mandate was returned on Wednesday, so your honor is vested again with jurisdiction to address this current motion. We're seeking essentially what will be a similar remedy, but now under the rules of criminal procedure, which is 3.220 LNM. And specifically, and I know your honor read the motion and is pretty familiar with this. And one of the issues, or really the main issue, was that the original warrant issued for the iClouds of Courtney Clenney, Kim Clenney, and Deborah Clenney, in our argument, invaded Kim and Deborah Clenney's privacy right under Article 1, Section 23 of the Florida State Constitution. But under the rules of criminal procedure, Judge, essentially this is just all sensitive material that should not be disclosed to the state. Our issue has been not simply the breadth of the warrant, specifically, Judge, the warrant allows the state to go through Kim and Deborah Clenney's iCloud data from November of 2020 to present is what's in the warrant, but that was November of 2023. So a 3-year period wherein the issue, the subject criminal offense, Courtney Clenney's homicide charge occurred April 3rd of 2022. So we've asked the state to narrow or at least advise what exactly they are looking for and why they believe there would be evidence of a second-degree homicide 2 years prior or 2 years after on the iCloud data of the defendant's parents who weren't even in the state at the time it occurred. By the state's own theory of prosecution, this was a heat of the moment incident that occurred and resulted in the death of Mr. Abumseli. So what we're asking for, Your Honor, is to restrict the disclosure to the state entirely, because I don't believe that they have sufficiently established grounds to invade Kim and Deborah Clenney's privacy to this degree. I understand and we can see that the state has an interest in prosecuting criminal offenses and has, pretty wide authority to do so and many tools at their disposal, such as a search warrant, but that's not unchecked. I'll also remind the court, and I think Your Honor knows, so the warrant at issue, this court has jurisdiction over, but also coincidentally, Your Honor signed the renewal warrant. Originally went in front of Judge Cabarga. She executed it. It was presented to Your Honor that had gone stale and you needed to re-sign it. So I think Your Honor also has wide discretion to act sua sponte on limiting that warrant now because you still have jurisdiction over it. Either way, what we're seeking is to prevent the state from invading our client's privacy. The court does have a secondary remedy available to it, which is to review the materials in camera and determine what, if anything, may be relevant and is worthy of being disclosed to the state. And the last point, Judge, is when the state sought this search warrant, the reason being that they could not access the defendant Courtney Clenney's iCloud or phone. They had requested the password. That was declined by Ms. Clenney's counsel. That issue has now since been remedied. So there's really no reason whatsoever for the state to have access to the defendant's parents' very private data.
Mr. Abioha?
Yes, Judge, and before I begin, may I just request from the defense the items specifically that they believe would be protected under some privacy interest?
Well,
You want the
Judge, we're talking
specificity from
about
them?
iCloud data. So I think that's been well established in Riley v. California that
No, we're going to pause there. So, Sean Abrahoff, the new lead state prosecutor, he was on the case before, but Khalil Quinnen was the lead before the oopsie happened. The failure to employ a taint team happened. He just said, well, can they just tell us specifically what they want? Like what?
Very private data.
Mr. Abduhoff?
Yes, Judge, and before I begin, may I just request from the defense the items specifically that they believe would be protected under some privacy interests?
Well, Judge, we're talking about iCloud data, so I think that's been well established in Riley v. California that the data that we keep on our phones and our personal computers and now in a cloud storage, we're talking about medical records, financial records, spousal communications. It's a digital vault that they are traipsing through.
And the accounts that are at issue, I'm assuming, are the KDC ones and the DEB.
Correct.
Right, the CTC is Ms. Clenney.
Yes,
Right.
and just in response again to Mr. Abduhoff, it's not this private citizen with a privacy interest job to tell you this is
Specificity.
what I don't want you looking at.
Get him.
It's the state's burden to say, I need to look at this because it is relevant to this prosecution.
Mr. Abduhoff?
So Judge, the issue here, and I will agree with the defense that they have standing under these specific statutes solely for the purpose to limit that disclosure. A lot of the case law that comes about happens once it's already in the state's possession, and the third party public record request comes about for these items in that disclosure. I don't want to necessarily go that far, but where we are here is this is a search warrant that this court signed that issued and agreed that there was probable cause for this, for the attaining to attempt to locate items relevant to this investigation. So at this time, that standing that the defense may have to limit possible disclosure does not call into question, cannot call into question, because they don't have standing to challenge the warrant itself. If they were granted the ability to intervene, we're in a different ballgame. That's not where we are. So they're talking now about what already exists and limiting its disclosure. Now that it's already there and it's already what would be in the state's possession, we're in a world where they're limiting, I believe their sole ability is to limit its disclosure to the public. So first off, when it comes,
I do not agree with that, Judge. I don't read the rule. I think it is far more broad than that. And it's important to note, Your Honor, that the decedent, Mr. Uphamselli, his counsel filed a similar motion for materials related to Mr. Uphamselli. So
I think that's also irrelevant to this argument per se, because whether or not it was granted the defense and the state were in agreement to limit some of the more sexually explicit conversations or things that the court deemed were obtained illegally, that's what the purpose of that protective order was. But that being said, Judge, if you look at the rule itself, outside of the first sentence, all of it talks about depositions and limiting what would come about. For this is section L. When it comes to the disclosure, the state can be limited in asking these questions or a witness to have to answer these questions. None of it pertains to items that are already in the possession of the state itself. These items itself, the court took possession of it after the fact and held on to it for the purpose of the appeal and whether or not they could intervene. And I believe the court's intention then was, okay, if they could intervene, we could talk about the breadth of this warrant, they would have standing to. Now they don't. You know, that the third DCA, the court said they did not, the third DCA approved and affirmed that they did not. And so what we're here now is talking about items that are already effectively in the state's possession, although the court has it. And now the question would be limiting it and basically its use in trial or disclosure to third parties. So where we are here, and when it comes to this item, these items, when the defense talks about financial records, that's very relevant to this case in and of itself. You know, when it comes to Kim Clenney's financial records, it was clear in the Arthur hearing that Ms. Clenney, the defendant.
All right, so when he says Arthur hearing here, that's like what we call like bond hearings down here. It's like an Arthur hearing is specifically supposed to be when you're facing a more serious charge. I guess they give it an extra name because it's probably going to be a longer sort of mini trial for the parties to argue for or against bond.
Sent all of her money to the defendant in the months leading after, even 1 or 2 months leading or preceding the murder itself. So we do have an interest in obtaining these items, finding the value within that, and seeing how it fits into our case for actions taken after the fact, as well as communications with Deborah Clenney that happened in the moment of this murder and homicide. So
That I get, but what we're talking about 18 months prior to the homicide itself.
So, and Judge, the issue comes is that all of these, I understand Your Honor is separating each account, and rightfully so. But when it comes down to it, all of them share one iCloud account. So when we do a return for this iCloud, all of this comes, and you can now attribute to each person their separate phone numbers. So they share, that's the first part of it. The second part is that
I think that
what
he has me questioning myself, but I'm pretty sure the warrants specified like Kim and Deborah Clenney's names for the Apple warrants.
Your Honor has just done is what the defense would like is to attack the warrant for being overbroad, for calling into question the amount of time in which we are being able to look at certain information. And they don't have standing to do that. And that's the problem here, is that they can't question what Your Honor found probable cause for in our investigation in trying to obtain certain information. That's why, they do have standing to question what could be turned over, or in a deposition of Deborah or Kim Clenney, what could be asked. But when it comes to what's already in the state's possession that Your Honor found probable cause, they can't question that and they can't challenge that.
So
They being the Clenneys, so in other
Well,
words,
not Clenney's, Kim and Deborah.
right, that's what I mean, not.
Yes.
Courtney.
I can address that as well, Your Honor.
Okay, so let me just make sure, were you finished, Mr. Agarhoff, or? So in your argument, if the motion to intervene had been granted, then we would rightly be in this discussion that we're having, but because it wasn't, and it was affirmed on appeal, it's as simple as a threshold standing issue,
Correct. And I actually, that's not correct.
okay?
Because standing would say whether or not they could even bring this motion altogether. The rules allow for them because they do have a privacy interest in the records themselves, but the question or the answer, the state has a competing interest in still reviewing and obtaining and ascertaining value to some of these items.
If I were to say that the privacy interests of Mr. Kim and Deborah Clenney outweighs the state's interest in prosecuting this case, what type of limitation would be appropriate?
What I would say, Judge, would be that, Your Honor, prior to any sort of public record request for these items, and this is obviously a very media-driven case where there's a lot of attention to it.
I feel
Anytime
called
that a
out.
public record request is done or requested for specifically these iCloud returns, that it could come before the court and we could be able to ascertain in camera or even, just off record of, hey, these are the items that you are not allowed to turn over to the public because that's where their public or their privacy interest now trumps the investigation or, I'm not finding the value. State, explain to me now why the public needs to, or you should have been able to ascertain or obtain these items.
So your position in that regard is this is not right.
To be fair, Your Honor, I've never seen the returns. I've never seen what's on these returns, and my involvement in this case when the returns came back, it was not as a first chair prosecutor. So I would love to say, Judge, this is everything that's on. But I'm not allowed to have communication with who was previously the first chair.
Right.
So I would say yes, but legally speaking, it could be right. Because in theory, there are people in our office that would have that information, just not any that we could discuss with.
What I mean by right is that the actual public record request has not occurred yet in this regard.
In that regard, then yes.
Maybe it has. Obviously, I don't know the answer to that.
If there are any public record requests for the iCloud warrant, we have not been able to answer to them because they've been in possession of them.
Okay.
So let me just address the issue of the public records request, because I think that's a red herring.
It might be because
Yeah.
it's separate and apart from discovery.
I agree, Judge, and I also need to point out that we're discussing a privacy interest. So for my clients, the state going through their private data is the same invasion as if
It was all over the
requested.
news.
It's
Yeah.
somebody who should not be looking at what is private and being allowed to do so. I also want to address, Mr. Abuhoff talked about under subsection L of the rule we cited to and said notwithstanding the first sentence, but the first sentence is particularly important because it is what gives us this standing on a showing of good cause. The court shall at any time order specified disclosures be restricted, which is what we're asking happen today. Judge, it's also important to note on the issue of the motion to intervene. And this is particularly problematic because I don't think even the state is arguing that my clients don't have an interest in their own data. The third gave us no opinion, so I'm not gonna, speculate as to what they think, but they did deny the motion to intervene, which puts us in a very interesting position because the state has sought very private data over a long period of time of two people who just happen to be related to a criminal defendant. And now is essentially arguing that we don't have any remedy before Your Honor. And that is a really, really steep and slippery slope for us to be on, because that subjects everybody who may know someone prosecuted by this state attorney's office to have their very private data reviewed. It's also, Judge, essentially a moot point because they have Courtney Clenney's data on the other side. So anything related to her, who is the defendant they are prosecuting, that may involve my clients, they have it through that back door. So there's no reason for them to be looking to private citizens' very private data on the other side of it. So, and again, I've yet to hear in all of the arguments, what are we looking for? With regard to the financial issue,
That
that's
sounded to me like it went more toward the motions that you, well, not you, but that Ms. Pavisi and Mr. Praetor raised with respect to her release.
say that again, Your Honor.
Well, the financial records and
Right.
whether or not Ms. Clenney has been provided with money for her to flee the jurisdiction.
It's a very
We discussed
interesting.
that.
Yes, Judge, because Mr. Clenney did testify at the Arthur hearing. Mr. Abuhoff's predecessor, who was removed from the case, put in one of his response pleadings that the warrant was sought for this information for exactly that reason, because they believed this was a movement of money, which was indicative of flight. The warrant was sought after the pretrial detention order was entered. So that's just a disingenuous argument to make. The idea that transfer of money for somebody who's now been in custody going on 4 years was not just a sound financial decision. It does not establish anything related to the elements of a second-degree homicide. And there's no issue of flight because she is detained. So that argument, I don't think has much merit, Your Honor.
Can I ask, if I agree in part with your argument, what limitation would you suggest? I realize for the record that you're objecting to everything and that this, in its entirety, but I think that some of this could be.
Sure, Judge. We offer in the initial motion to allow for a limited release of the phone calls or communications between Deborah Clenney and Courtney within the time period of the homicide. I can even concede that that would be relevant and important to the state's investigation, but to have 3 years of private data for a very limited window of time, I don't see the state offering the court anything compelling. As far as our standing to challenge the warrant, I'll concede that point that Mr. Abuhoff made, but that does not prevent the court, having reviewed the warrant, from acting sua sponte with your jurisdiction over it, to limit it and say, okay, well, what are you looking for, state? Give me more specifics.
What is the earliest date of, because my notes are in my office, the earliest date of some of the interactions that we litigated of, I don't know, a month ago or whatever, prior
Oh, sorry. I was just gonna see if I could move.
to the homicide?
Nope.
And Judge,
Can't move
that's
the
the
captions.
problem. We turned over for the Arthur hearing. There's the specific incident between Ms. Clenney and her parents when she's about And I'm guessing right now it's either 12 or 14. It's sometime in that range. So that's many years before. And this idea of,
Yeah, I don't care about that. I'm talking about.
I understand
the
that.
Defendant and the alleged victim.
And I understand that. So their relationship is about 3 years, or about just under 3 years.
All right, so what he's referencing, my details are blurry, but there was an incident where I believe Courtney was fighting. I think it started with a fight with maybe her sister or the sibling, and mom got involved in the fight. Started to move on to being a fight between Courtney and her mom, and then they, out of concern because the fight was escalating, the police were called, and this is when Courtney was like pre-teenaged. So that's what he's referencing there. And I don't think it was answering her question.
Prior to the murder. It's on and off. There's multiple conversations, but that's the problem here is I believe that date coincides with when that relationship began. And it's seeking, and a lot of the conversations and knowledge of the Clenneys, they were quite aware of what was taking place between their daughter and Mr. Elcomselli, to the point where the week before the homicide, Deborah Clenney is coming to the apartment to now address any sort of issues as to what is going on between them. So there's knowledge between the parents and their daughter and their daughter's relationship. And I believe that is why the date was what it was. I wish I could give Your Honor more information as to that, but that is, at least it coincides with when we believe his relationship with her began.
So, Your Honor, I'll allow Ms. Puglisi to make the relevancy objection to all of that when it's appropriate.
Yeah.
I mean, that's a bridge too far.
I know.
So Puglisi is Courtney Clenney, one of Courtney Clenney's attorneys. So relevancy would go to an admissibility issue at trial, and Jude Faccidomo is there on behalf of Kim and Deborah Clenney, the parents, who it's not an admissibility at trial issue, it's a privacy disclosure issue.
No, I know. I just was trying to get a sense of,
And Judge,
because I signed this 3 years ago or something.
Yes, ma'am.
So I obviously can't recall what was in my mind or anything at the time. So
and I'm sorry,
it does seem overbroad.
I apologize, Your Honor, for interrupting.
Oh, very cool. So one of the warrants was from a different judge, but another warrant was signed by Wolfson. And that's very interesting because we just got done reading Kim and Deborah Clenney's motion for this protective order for this information. And Jude Faccidomo and Mickey, they write in there, although we want the initial judge that signed the search warrant, we want deference to be given to that judge. The next judge that's reviewing it should be able to give like a substantive look into whether or not that search warrant may have been overly broad. And now thinking about that, that's such a great thing to put in there because it's the same judge. You're inviting her to review her own work.
But the question of whether it's relevant
I know.
doesn't necessarily mean that it's overbroad. The idea is their relationship starts at a certain date. It is certainly relevant. The question of whether or not it's relevant to the trial and whether Your Honor will allow us to go into it as to some Williams rule component, that's separate and apart from PC relevant in this case. And I believe that's why, although Your Honor now is looking back and saying it might be overbroad, it's relevant to their relationship. And so it's not a fishing expedition for things. It's seeking information of knowledge between very pertinent and important witnesses, especially Deborah Clenney, who is on the phone at the time of the homicide and even potentially after the homicide, or at least we know for sure after the homicide. And Kim Clenney, who's on the phone, or not on the phone, but in discussions with their daughter, moving her out after the homicide and financial actions after the homicides, but also their communications beforehand with their daughter.
Harkening back to what I said a few moments ago, in that I do believe that to some extent, Mr. and Mrs. Clenney's privacy interests outweigh the state's interest in prosecuting the case. If I were to grant the protective order from November of 2021 to 2023, no, April of 2021 to November of 2023, how would that harm the state's ability to prosecute this case? And that would call into question the fact that I do believe to some extent that their privacy interests outweigh the prosecution.
So in this, the problem here, Judge, is that when defense comes here and asks for the entirety of these iClouds, the problem is that there are specific items that would be relevant. So Deborah and Kim could be Williams rule witnesses. I won't know until I get to review these iCloud warrants, which have been in the court's possession for the last couple of years. Right now, we have a pending Williams rule motion,
Right.
but we can only litigate it so much so until we figure out their knowledge and their witnesses to what exactly, I don't know. So the date range that you're on.
All right, I had to look that up. So the Williams rule in Florida, because we have to give a name to everything here, allows the introduction of evidence of a defendant's prior acts to establish certain aspects of their character, such as motive, intent, or knowledge when relevant to the current case. So it's their 90.4042 motion. So numerically, they're adopting the federal 404, like character evidence stuff, but they're naming it the Williams rule. So we're just gonna put labels on it because we're fancy down here.
Honor suggesting, I believe that you're cutting the state out by its legs when it doesn't necessarily have to. At the end of the day, the protection, the privacy interests that they are seeking, I think is covered by limiting who is able to see it after. So if the public cannot receive it, the question is still, it may be relevant to prosecution and what the state may be able to use.
But how are we 4 years in and you don't know the answer to that question?
Because Your Honor has had the iCloud warrants or the returns for the last 2.5, 3 years. The only person who reviewed those prior to is no longer on this case, and I can't speak to him. So
Judge, the point Mr. Abelard just made is very telling.
He's not doing his
They may
work.
be Williams rule witnesses, but we don't know, so we want to go fishing through their data to maybe explore a 404 motion. That's putting the cart before the horse. The state needs to have some reasonable belief that these witnesses have relevant information, so much so that they're going to be allowed to be called separate and apart from the facts of the trial and put up as Williams rule witnesses. But the answer keeps coming back. What are you looking for? I don't know because I haven't looked yet.
that's not my understanding.
Well, you don't know because well, partially, but you can't speak to the other prosecutor as well.
So, and this is the problem, Judge. So, we specifically were looking for communications, financial data. They can't be separated out. When iCloud receives these warrants, they're not picking and choosing. They're not the ones who go and say, hey, here's exactly what you requested. They are taking the entirety of it. They're sending it to us. At that point, we end up sending it over to the defense, and the proper way of handling this is having a taint team be able to review it. And hey, defense, we're not looking at it. It's in possession of the taint team. Tell us what you believe is something that should be excised out of it, which can still be done here because anyone who does have knowledge of this is not on this case anymore. So what can be done, what should be done is this is given to the taint team that the court has approved.
So they can't go talk. They're talking about Khalil Quinnan. So they're not supposed to talk with Khalil Quinnan because they don't know if he has information that the prosecution team is not supposed to be aware of. So in a way, Khalil Quinnan is like sequestered from his peers who he works in the office with every day, at least as it relates to anything that would be relevant to this case. So nobody that's prosecuting this case is supposed to have communications with Khalil Quinnan about this case or anything that might be like ancillary related to this case. So that's what they're talking about when they're saying I can't talk to the guy that knows. They mean Khalil Quinnan, who was like disqualified / stepped down himself before he got disqualified.
Which now can happen since the appeal has come back.
Correct. And so now that these items are here, they can be taken by the taint team. The defense who received copies of this at the time that they came in as part of discovery should be able already to know what's on this rather than the state, because anybody who had knowledge does not. If there's anything that they want excised off, then they should be able to bring that to the taint team that they can take it off. If there's a question truly of, does the state have a competing interest in this, then we bring it to the court and say, Judge, we're not in agreement. But this is something that should be taken off, like outside of the presence of the court. We can handle this together in theory until we can't. Like that's why it's not. the defense should be able to lay out exactly, even broadly, to the taint team, hey, all of these items should be taken off. We should be able to say, hey, we're in agreement completely, and then it's not an issue. If there's an issue, now we bring it to the court, and Your Honor can now look at it and make it.
Mr. Faccidomo, are we premature?
No, not at all, Judge, because the state's conflating an issue here. The taintee is applicable to Mr. Puglisi and Mr. Prieto as the defense. I'm not the defense here, Judge. I am protecting my client's privacy interests, which frankly applies when members of the government, the state attorney's office, is reviewing their private data. It's a constitutional amendment in Florida's constitution that creates a robust privacy interest. That argument pertains to whether privileged communications will be reviewed and is more applicable to Courtney Clenney and her defense team. Our position is, you're the government. You don't get to look through private citizens' data just on a hunch because you think there may be something in there. And that's why we argued the warrant was overly broad. They didn't identify anything that they're really looking for and still cannot tell this court. And this is probably the fourth or fifth hearing we've had. Nobody's been able to say exactly what they're looking for. So we're just going to open up a digital vault and let them peruse it at their leisure and look through very private material while trying to find something that may be relevant that they don't even know if it exists.
What is your
Hold on, I can't. I want to cover the couches. I got to put a little fire up.
position as to a possible limitation that I suggested previously?
So I think that's actually a fair comment.
He's not the defense. He's not representing Courtney Clenney. His clients are Kim and Deborah Clenney, who are third parties, because they're not charged in this case. So the reason he has to point that out is because the argument that the state attorney, Sean Abahoff, was making is, well, the defense, the person on trial, can go to the taint team and say, hey, this is what you should exclude, filter this out because it's my attorney-client privileged communications. It's a totally different argument and analysis than what the moving parties are arguing as far as their privacy interests. So, and his standing comes in because it's the iCloud information and the hardware devices. I think it's both, but I think they're looking more at this expansive iCloud issue because it's more to deal with practically, and it's the iCloud information stems farther back. If someone got a new device, that might not be so old. So they have standing because it's their information. There's some argument that, of course, Apple's technically the owner of the iCloud servers where this information's being held, but it's the privacy interest is what gives the party standing. So.
Compromise, Your Honor, but I would suggest this. I think the date would be limited from April of 2021 to when Ms. Clenney, Courtney Clenney, went into custody. Because their argument was that they want these communications. Any communication she had with her parents while in jail, they have ready access to through jail calls. So I think if we limit it to around the time of the homicide to when she's taken into custody, the state's interest is preserved. It respects the very robust privacy interests of my clients, and hopefully this case can proceed to trial as scheduled. April 2022, thank you.
Judge, specifically to that April 2022 date, now that cuts out anything beforehand. So you're eliminating any sort of Wilkins rule information that these parents may have.
All right, the motion for protective order as to April 1st of 2021 to August 26th of 2022 is granted.
Thank you, Your Honor. I'll draw a motion. Oh, wait.
Sorry, what was the date? So April 1st,
It's April
2021.
2022, Your Honor, is when the homicide occurred.
That's not what my order is. It's 2021. I'm allowing it the year before.
And Judge, forgive me, but let me inquire of the court, if you don't mind, what's the rationale for the year prior?
The continued, well, you know what, now that you say it, it's the communications that I think would be appropriate, but that's part of Ms. Clenney's.
And they have access of that through Ms. Clenney's material. Also, Judge, the argument that she may have discussed her relationship with Mr. Obumseli with her parents, and therefore the state should be allowed to see that. Again, creates a very slippery slope because you're allowing private data of parents who are having communications with their child about their relationship to be looked at because they may indicate their feelings one way or the other. There's this homicide is being prosecuted as a heat of the moment second-degree murder. So any discussions that Courtney Clenney had with her parents about her relationship is trying to shoehorn in something that's not going to ultimately be relevant or admissible.
Which is again not your purview necessarily.
Fair enough, but while I'm trying to protect my client's privacy interests, I'm addressing the state's argument to say, hey, they might have talked about the relationship, so we should be allowed to look at that.
I'll give you one last comment on that.
So Judge, specifically to that point, defense says that there's a privacy interest between conversations with themselves and their daughter. That's just not true. That's not protected by Florida state law, not protected by federal law. And specifically now you're bringing in a party to this dispute, marital spouse, if we want to talk about those communications, that is the only protection that could pertain here. But once Courtney is a part of it, that is waived when it's brought to another person. So the discussion that they want, the question here is relevance, and that's what they want to argue. And that's really the only thing they can argue. It can be completely relevant, which is why when that relationship is going on, which is why the beginning of the warrant was the date that it was. So yes, that's what every search warrant is. If we knew that every conversation was in there, then yeah, that's great. But realistically, you're saying, hey, we have probable cause a crime was committed. This is the parent. These are communications that were had after the fact. We want to ascertain their communications before the fact. So this is very normal in the sense of all search warrants ascertain a specific amount of data for specific purposes. These communications now, even limited by the court, I think may go too far. We respect the court's ruling and we'll abide by those. But at the same time, it is relevant.
I'm going to stand by the 2021 date. So if you could draw up the order.
I will, Your Honor.
And the bottom line is, as to Courtney Clenney's iCloud, it's all still fair game with the dates that are in the search warrant itself.
I understand that, Judge, and that's.
Yeah, and Judge, are you allowing the state to look through everything or just communications? And just very briefly, Your Honor, I was not making a privilege argument. I was making
we're not there.
Right. I was making a privacy argument.
Right.
But again, I guess my question to the court for purposes of this order, the state's arguing that they need these communications.
It's limited to communication.
Okay. All right.
Judge, I would argue that financial records matter as well. I mean, there's an argument here, Judge, that specifically.
Hold on. I don't know if you heard that, but she said she disagrees.
Making a privilege argument. I was making
we're not there.
Right. I was making a privacy argument.
Right.
But again, I guess my question to the court for purposes of this order, the state's arguing that they need these communications.
It's limited to communication.
Okay. All right.
Judge, I would argue that financial records matter as well. I mean, there's an argument here, Judge, that specifically Mr. Obumseli was, for lack of a better term, leeching off Miss Clenney throughout their relationship. She's getting money from her parents.
Turn into a telenovela. Okay, so
But
that's the issue.
So
Let me just say this. If during the course of your investigation, now that you're able to go through everything, that we're back to where you're able to do that, that you need to revisit something that's part of the court's ruling, then you'll do it. But as we sit here today, it's communications.
So Judge, and that's why what I'm talking about now is during that argument hearing, throughout that entire transcript, the defense argued that Mr. Obumseli was leeching off, which is why he's back at that apartment. We need to be able to ascertain because she's not making the money that she's making at the time of the homicide for the year before. So that's why financial records are going to say, hey, Kim is sending money to their daughter for those during those purposes. So financial records are relevant for this purpose. And that's why
Can you get that another way?
Defense is asking for everything that other than conversation.
Why do you need to get financial records from iCloud? Like specifically from the parents. Like in a transaction, there's two parties, right? Someone sending the money and then the pass-through, the processor who receives the money. And then one would think you can subpoena those records from the institution, the payment processor, if it's not somehow also on Courtney's devices and things that you've subpoenaed in relation to Courtney. So why is this an argument that applies to why this should supersede the privacy interests and this order should grant permissions beyond just looking at communications between Kim and Deborah, Kim and or Deborah, and Courtney Clenney?
But other things that are inside of this iCloud are pertinent to this, including medical records. They may be in receipt of medical records. Courtney Clenney, who actually claims that she's been a battered spouse. So this is important. And to limit us to be able to obtain these items that could be there is a problem.
That notice for intent to rely on battered spouse syndrome is like, what, a year old now? And you didn't know this yet? Like, why aren't you starting to look for this stuff? Like, trial is set for April 27th.
So, Your Honor, we'd ask for the date range with everything. The defense has it. They should be able to tell the court, hey, Your Honor, this is here. They shouldn't be able to look at that.
I mean, I think Mr. Faccidomo's argument was that, you know, private citizens should not have to tell the government what they can and cannot look through when you're not a party to a case.
Right, and that's why we come here, Your Honor, and it talks about specific disclosure of those items. So they have it, and that's why they have possession of it. They should be able to tell the court, you shouldn't be able to look through this because this in fact exists, and we have an interest in this. Then we'd be able to actually have an intelligent argument with the court to say, Judge, this is why this is relevant to us. To now blanketly just say, medical records. That's not what this statute is meant for. And that's the problem that we're here now, is that they're blatantly asking the court to cut out everything for that date range. So, Your Honor, the date range itself, we'd ask for everything in there. We're happy to provide a copy to Mr. Faccidomo. If he's arguing that we don't have an interest or their privacy interest trumps something, again, that's why the taint team is here. So this is something that I think, again, it's putting the cart before the horse.
Again, that's his argument.
Throughout this.
Look at you. And I'm saying his name wrong. It's Faccidomo. That was his argument. So how is it again putting the cart before the horse when that's what the other, I don't want to say the other side because this is a counsel for third parties, right? This is an additional attorney in here. That's not part of the defense.
It's putting the cart before the horse. It's something that can be handled throughout this process. And now to sort of blanketly say, state you can't look at anything but messages, now cuts out potential evidence that is more than relevant and may come into this trial.
Is it just silent? Oh my God. They're just quiet. She's reading. Yeah, that's a great point. Adventure Aaron says it's a disingenuous argument. They can't admit medical records through the parents. Parents can't authenticate those, even if they are on the phone, because it's hearsay. Very, very sharp, Aaron.
So essentially, Mr. Abuhoff, you would suggest that the court rule that the date range that I know you're not in agreement with the date range, but it is what it is. That all of the property that is contained in pages 2 and 3 of the affidavit in support of the search warrant be allowed, notwithstanding whether it has to do with communications.
Right.
Mr. Faccidomo, any last word? I actually think I'm revisiting that at this point.
Well, Judge, if you're revisiting it, then yes, absolutely. I think the state's argument is essentially shifting the burden onto private citizens to prove that they have a privacy interest in the data that they want to look through. That's just not how the constitutional amendment works. It was very much designed to create in private citizens a robust privacy interest. To say that we think there may be something of relevance in here, and I frankly, I said this with all due respect, Mr. Abuhoff, I think the financial argument's a bit tenuous at best. It was originally raised as, like Your Honor pointed out, as an issue of whether Ms. Clenney was a risk of flight. So going through private financial records for which my client's interests are protected doesn't have any relevance to a second-degree homicide trial and trying to shift the burden onto us to tell the state what we think is private in our private material is not the right calculus for this court. They should be able to tell Your Honor, this is why we think this, and point to, with some specificity. I get that they need to review evidence and items that they receive from a search warrant before they can decide if it's going to be relevant to the trial. But there needs to be at least a certain amount of specificity. Your Honor saw this warrant. It simply listed everything that's included in iCloud data. So I think asking us to then tell them what they shouldn't be looking at is shifting the burden onto us and making private citizens responsible for telling the government, here's what you can't see.
And I think I would agree with you 100% if the taint team was not in place in this case. I think that is the safeguard at this moment in time. So
May I respond to that?
yeah, go ahead.
So again, I have to bring this point up because, and Your Honor,
For Courtney,
Article 1, Section 23 states every natural person has the right to be let alone and free from governmental intrusion into the person's private life. The taint team are members of the state attorney's office. They are the government intruding into my client's private life, who are not charged with a crime. They were, but that was folly and dismissed. So partly because they invaded privilege. So there's all sorts of problems here. They have a right to be free from governmental intrusion. The issue of the taint team is more for the trial against Ms. Clenney. Kim and Deborah have a right to not have random members of the state government look at their private data. That's what the amendment is for.
I'm going to rule that from 4/1/21 to 8/26/22, the protective order is granted. It will solely be as to communications at this point for that period of time in the course of your investigation.
so this back and forth that just happened after she initially gave the date range, where she was like, oh, well, maybe, and then Jude said, well, let me argue more if you're actually reconsidering. He just won this reconsideration. Jude Faccidomo just won for Kim and Deborah Clenney. No, you shouldn't expand this beyond the communications. And you shouldn't just let this be, now we, as third-party private citizens, need to go out of our way to go through this trove of data. Like, think about how burdensome this is. They obtain everything through the search warrant. Because the search warrant is so broad, it's got to be like terabytes upon terabytes of information. And now Abahoff is arguing you've got to go through that and go tell the taint team what you don't want them to go look at and to filter out. If the search warrant was narrower to start, it might not be so burdensome to navigate that, even though I think Florida, the Constitution, the way it's written, again, they don't have that unreasonable qualifier before private citizens have a right against government intrusion. It doesn't say unreasonable government intrusion into their private information, right? We do not have that qualifier in the Constitution. He's leaning heavily into that in his argument. He's not forgetting the fine points that he needs to emphasize. And he won this argument with this judge. This is awesome to watch. This is awesome to watch. I'm a fan of this guy.
If you wish for the court to revisit that, then you may do so. But at this point, it is limited to communications.
Judge, may I ask for clarification on the communications? Is it between my clients and their daughter or any communication with anyone?
Yes.
Doctors, lawyers?
Yes.
Okay.
Judge, so just so that I'm clear, so as it pertains to your warrant that you signed initially, is Your Honor ruling that it was overbroad?
As it pertained to Kim and Deborah Clenney.
And then when it comes to the items that are sought, is it Your Honor's purview that the standard for obtaining a warrant is what the defense has said that it is here? Whereas, in reality, the question just comes whether there's probable cause to believe that relevant evidence could be discovered. during these searches. Because they're
Right, but
seeking.
now we're 4 years later. We recognize where we are procedurally, and as it comes to the two private citizens that are at issue, it's a very different calculus than it was back in whatever, November of 2023.
But it's not though, Judge. The only difference is what we're effectively here for is now a motion to suppress. Because the items have already been obtained. So the question would be whether or not those items.
Cat, I'm not a lawyer. Is a motion to suppress the same thing as a protective order? This is not the same argument. A motion to suppress would mean something cannot come in. It's admissibility. I would not equate motion to suppress with a motion for a protective order.
And that's why, they can limit the discovery of it in some respect. But we have our own interest in our own property. So those iClouds that the court has maintained possession of is the state's property in and of itself when we obtain those items. So that at that point, we're no longer in this world of 3.220 as it pertains to a protective order for the state, because it already has it. Where we are now, and that's where the argument is that it goes to the public disclosure of it. The question of whether or not we can now look at it goes to a motion to suppress. And now that's why this is the standing issue in and of itself of whether they can raise this under this statute. So with that in mind, we have to ask the court at least to lay out its argument here that this
They're
is
gonna
not
appeal
the
this.
avenue where it is. Just
Are they going to appeal this decision? Are we going to get a delay in this trial because they're going to appeal this decision?
with whether it's on record or in a written order, because this slippery slope now allows for any defendant to say that someone that's not arrested can now say, you can't look at my records other than communications with this person.
But that's when there's a reasonable suspicion to believe that a crime has been committed. That doesn't apply to Mr. and Mrs. Clenney.
But it does as it pertains to evidence of a crime. And that's the issue, is when we're talking and discussing the nature of a relationship, a lot of things become pertinent. And that's the problem here. That's why I have no issue with the court limiting the dates. And perhaps that's something we could have done before, but limiting the dates to what Your Honor did, but then to limit the evidence within those dates, that's, Your Honor is effectively saying we don't have probable cause to believe that any of that could lead to evidence of a crime. And I just think that's a slippery slope.
I can't think of a reason right now why that would, because you're prosecuting this as a heat of passion crime.
No, Judge, we're calling this a second-degree murder, where specifically she is reacting as nature, as part of their relationship over time, over the 18 months of this that boils over. So what the state would argue, she now stabs him in the chest. Defense now wants to call it a heat of passion crime, but this is a buildup throughout it. And there's
So Mr. and Mrs. Clenney's medical records would have something to do with that?
And I'm not saying that that specifically wouldn't, but your order, Your Honor, cuts out everything else, including the medical records. But that's why I can't even tell you if it's on there, and that's the problem. The problem is right now, if Your Honor wanted to look at the iCloud dumps itself and lay out specific items, fine. The only person who has knowledge of what's on those iClouds is the defense. And they haven't put anything in front of the court to say, by the way, there are medical records on them. They said the likelihood of it.
I can put that on the record. I'll put that on the record.
Okay.
It's in iCloud.
Oh, he's ready.
Everything's there.
Everything's on it.
That's not how this works.
Okay, I'd say,
But this is.
I've got a packed courtroom full of people who are waiting. It's now 9:52. If we need to litigate us more, we can at the end, but I thought I had ruled. And I think
agree.
new issues are now coming up. All of
Yeah,
them.
and Judge, what I'll do is I'll draw up an order in accordance with Your Honor's ruling. I would suggest if the state finds something in those communications that allows them or leads them to believe that there's additional information out there, that's how an investigation should
And that would
progress.
be
And
brought back.
then we can readdress it with the court.
But Judge, so I would ask that we
Judge,
recall this case at the end
You're
of
gonna
calendar.
continue to argue?
Yes, I would ask that this be brought up at the end of calendar. There's still more.
I am restricted in my time, Judge, and I understand the court has.
Yeah, I
And
think I
just
had,
as Your Honor was rethinking your ruling, and then they had a final conversation, I have now asked Your Honor, and Your Honor, now there's more topics to be discussed. This is a slippery slope, and this is a big problem, Judge. Because at the end of the day, Your Honor granted probable cause for an entire range. Your Honor read through that warrant, found that there could be evidence to suggest of a crime to support that crime, and now Your Honor is rethinking, saying it was overbroad. Fine, but the idea to limit what the defense says could be on there. The idea is that that's not our burden to show. The idea is to say that there could be evidence of a crime. If they want to come before the court and say, Judge, this specific item is here, we'd ask that that now not be allowed. That's different than what is happening.
I don't agree with that.
Okay,
So here's what we're gonna do. He's gonna draft an order. He's gonna show it to you. If it comports with what I've said right now, fine, I'll sign it and execute it, and you can move for a rehearing.
thank
All
you.
right, we're back
Thank you.
4/16, but I wouldn't mind having a date before that.
4/16 was the
That's
final
not-
sounding here.
Yeah.
Can we do please don't do a status
Yes.
date for that in maybe early April? We have some depositions coming up end of March, beginning of April, but there's a lot still to do, and I think it would be helpful for us to do a status.
How about 4/1?
Can we do after, because we have depositions through 4/3, so can we do it after 4/3? Because that'll give us an idea to tell the court who showed up, who didn't, and.
The problem is that's gonna put
Oh,
us on
that's right,
Yeah,
right.
yeah. So it would end up being like 4/10.
No, I understand. 4/1 was good, Judge.
Okay, 4/1.
Is that amount?
It's a
Wednesday.
Yes.
Seven. You have that was at 1, so we're.
All right. Thank you all.
Thank you.
Have a nice day.
Wow. Well, it's crazy. The Sean Abahoff, there's been issues. There's been deadlines since, I would say, really since this November, December chain of hearings that we had. We had a bunch of hearings. Some of them were moved. A bunch of deadlines were set. And the state, and that's all in relation to Courtney Clenney and not with anything that Jude Faccidomo is doing with the parents here. But the state was supposed to do this, and they're like, hey, we might need a little more time for these two issues. And she's like, okay, well, I'll give an extra week for you guys to have time to do those. And then the deadlines passed, and they hadn't done what they were supposed to do. And just this whole hearing to me seems like you're not prepared to argue the issues. There's a brief on the docket from Kim and Deborah Clenney where they state, the state's arguing that this is an issue of standing. Here's why it's not standing. So you could have prepared by at least looking at their motion and knowing the points that would be argued, so you don't start conflating issues mid-argument, going off the rails, and losing the point of the question and the point of the arguments. And then when the judge issues her ruling, almost listens to you, but then winds back in and says, nope, I'm going to keep it to the narrowed time window and just the communications. You start rattling off. Maybe have that pep in your step through the process the rest of the time. But I'm glad they have a hearing date set for April 1st. And it's weird. I assume that, hey, whatever else they were going to hear today, since it was a status hearing set before this motion was raised, I'm like, oh, they're going to have to look at those issues on another day because this ate up all the time. I guess on the 1st, we're going to come back on April Fools. We're going to see if the state has it together and has actually done their homework over the next 11, 12 days to see, hey, do we actually have a more pointed, specific argument of why we think we need to look at certain things because they may be relevant and we want to continue this argument? And he wanted this attorney to be on his time. And again, I think the Clenneys do have money. Should they have to pay extra billable hours to their attorney because this guy wants to make them wait around all day? I don't think that's a fair argument. And it's an argument that would be totally impracticable, if that's even a word. Impractical. It wouldn't be pragmatic. It wouldn't be possible for people that could barely afford their attorneys. So, and remember, this is not the interest rights that they're fighting for here. It's not in relation to a criminal matter anyway. It's their third-party interest. They're not the one that's being prosecuted here at this point. They were formerly being charged for, the charges and related to the laptop. But this is a privately retained counsel, and it's now a matter where even if they didn't retain him, they wouldn't be entitled to counsel to fight this issue. And you want to just say, hey, I'm throwing a fit about your order. So as soon as you're done with your calendar, because you want to cut me off, Judge, let's all stay here until the end of the day and come back to this until I get my way. That's really how it feels. That's really how it feels. So, anyway, you guys know my gripes on the state. And the reason I wasn't going to be interested in the Courtney Clenney case when everything was starting to happen. I'm like, you know what? I don't know. I'm just wasn't all that interested in it. And the state's shenanigans got me to this point. And I just think this demeanor, this attitude, this approach, it's so lackadaisical by the state. They're not prepared. This is a defendant who, granted, maybe she comes off as she has money and she did something wrong, so who cares if she's sitting? I don't think that's a good argument to make for anybody that's sitting awaiting trial. That, so what if there's delays that the state caused? No, if the state's causing delays, fix the problem. And this is just another demonstration that the state doesn't seem to care. So, Fellowship of the String comes in as I'm rattling off. Good to see you, good to see you. And hey, sunshine for you guys. This was sort of the end of the... I say sort of the end of the hearing because they're going to continue this hearing on April 1st. But as far as what we're able to watch today, that wraps it up. I have a birthday party I've got to hit the road for in a little bit. It's not like anything fancy, so don't worry. I can get ready real quick. All I'm going to want to talk about is this, though. I'm going to be standing there like, talk about anything else. Talk about anything but court and motions and Courtney Clenney. Just don't even bring it up. Don't be that person. So we'll see if I can do that. I'll report back to you guys. Again, if you missed the beginning of the stream, we did go over the motion prepared by Kim and Deborah's parents that I think really interesting read. You can either rewind and watch it or it's linked in the description. We'll be looking for a feed on April 1st to see how these arguments continue. So looking forward to that. And I didn't see anything else on the docket except for, that this was granted in part. I didn't see like a written out version of it yet, so Faccidomo hasn't prepared that. But anything I do see come up on the docket, maybe the state will actually prepare a reply and file it. Who knows? I'll pull that up. We can either do a stream or I'll share it with you guys and read it whenever we get back together again. On the way out, we got some party favors here. Big thank you to the Honorable Sheriff Chuck here, gifting 5 memberships to send us off for a great Friday night. You guys all have a great one. Maybe this weekend we'll get together and do some deposition readings for Afro Man. I don't think we have videos available now, and rather than wait, we can read them. So you'll get me reading in Lisa's voice and Afro Man's voice, whatever you guys want. I'll put on my voice. So you guys all have a great weekend. See you next time. Bye, guys.